Good, thank you. Good afternoon, everyone.
Good afternoon.
We're on the record in Center for Environmental Transformation versus EMR Advanced Recycling LLC. The New Jersey DEP, this is docket C60-25. Council, your appearances, please.
Good afternoon, Your Honor. My name is Van Broughton. I'm with the Eastern Environmental Law Center, representing Plaintiff Center for Environmental Transformation. Thank you.
Good afternoon, Your Honor. I'm Daniel A. Greenhouse with Eastern Environmental Law Center.
I didn't hear your last name.
Greenhouse,
Thank
just
you.
like it sounds. Thank you.
Good afternoon, Your Honor. Nicole Noche with Mango Gold Catcher and Fox on behalf of defendant EMR Advanced Recycling.
Michael Dillon, Mango Gold Catcher and Fox, on behalf of defendant EMR Advanced Recycling LLC.
Good afternoon, Your Honor. Chris Orlando, Park McKay, on behalf of the EMR.
Good afternoon, Your Honor. Alana Petroni, DAG, here for New Jersey Department of Environmental Protection.
Good afternoon, Your Honor. Kevin Fleming, Deputy Attorney General, also on behalf of the New Jersey Department of Environmental Protection.
Council for Center for Environmental Transformation, your application, I'll hear from you.
Your Honor, we're here asking for preliminary injunctive relief to require Eastern Metal Recycling to remove stockpiles of flammable and dangerous materials at their site on a regular basis to ensure that further fires do not occur at the site to protect the community and the environment.
Then let me stop you. You just asked this initial question. Why are you here as opposed to at the Appellate Division or at the Office of Administrative Law?
Because we tried to resolve this with the Department of Environmental Protection already.
You just have to speak a little bit louder because the acoustics are so that you're fading.
Yes, Your Honor.
Thank you.
Because we already tried to speak with the Department of Environmental Protection many years ago and asked them to enforce EMR in a different way that would be more protective of the community and prevent fires, and that did not occur. So we are coming to the courts to ask for relief.
You did that many years ago,
Yes.
is that correct?
Yes,
And you asked them for relief and you didn't like the response you got, correct?
correct.
So why didn't you file an application with the Appellate Division or the Office of Administrative Law? So my understanding is, and I just maybe, when I looked it up, that if I looked at the court rule, if you don't like the decision you're getting from the DEP, it directs you under the court rules to go to the Appellate Division.
Well, it wasn't a formal decision. It wasn't a permitting decision or anything of that sort. So I don't believe that that's an avenue that we could take in this case.
So you just had conversations with them?
Correct.
Okay. And your conversations were directed at the classification of EMR, correct?
Correct.
Did you file a challenge to that classification with the DEP?
No, Your Honor.
Okay. We can keep going, I just wanted to understand how you got here.
Yes, I understand. Right. Well, I wanted to start out with just a little context about the situation here. This is an issue of environmental injustice, Your Honor. EMR is in the Waterfront South neighborhood where our plaintiff CFET also has their principal offices. CFET is a community-based organization that uses advocacy and education to transform the Camden community into one that has access to clean water, clean air, and healthy foods, and works to create a more livable and healthier environment for the people of Camden. And so one way of doing that is addressing the disproportionate amount of pollution that this community faces on a regular basis. There are over twice the number of permitted air polluting facilities in the Waterfront South neighborhood compared to an average New Jersey zip code. and it is a predominantly community of color, so a lot of black and brown folks live there and are disproportionately subject to pollution from facilities like EMR. And one of the biggest impacts that this community experiences from EMR is the severe fires that have occurred periodically since 2016 and more frequently since 2021. The most recent fire was actually last month after we initiated this case, and a more severe one occurred in February of 2025, which led to over 100 community members evacuating their homes, led to severe respiratory impacts, especially folks who experience chronic illnesses and asthma, and people experienced smoke in homes and soot on their private property as well. So within that context, we wanted to ask for that preliminary injunctive relief. So while we were looking toward the final relief of getting EMR classified as a solid waste facility as opposed to an exempt recycling facility, we wanted to ask for preliminary relief in order to prevent more of these fires, since they are the most severe impacts that EMR has on the community. And so, Your Honor, I also wanted to distinguish between two legal standards that are at play here, because we have the standards for the preliminary injunctive relief, and we also have the standard for defendant Department of Environmental Protection's motion to dismiss, which are really different standards. So in order for Your Honor to grant preliminary injunctive relief, as the plaintiff, we would have to show that the relief is necessary to prevent irreparable harm, that it is based on a well-settled legal right, that plaintiff has a reasonable probability of success on the merits, and that the relative hardship to both parties favors the plaintiff in this case. Additionally, when it's an issue of significant public importance, the court must also take into consideration the public interest in granting the relief as well. And the court may also place less emphasis on a particular crow, those are called the crow factors based on the case Crow v. DeGoya. And so the court may place less emphasis on one of those factors if another one greatly requires the preliminary injunctive relief requested. And so contrast that with the standard on a motion to dismiss under New Jersey Court Rule 4:6-2E, which is very generous toward the plaintiffs. All of the allegations in our complaint must be treated as true under that standard, and need only suggest a cause of action. We don't need to prove the factual allegations at this point in the litigation. So, and that a motion to dismiss under that rule is only granted in the rarest of instances as well. So now I'm gonna pivot to our main legal argument, which is that Eastern Metal Recycling is a solid waste facility called the Materials Recovery Facility because it receives commingled solid waste and recyclable materials and separates them out, which is the definition of a materials recovery facility, as opposed to defendant's argument that it is a scrap metal processing facility and a scrap metal shredding facility under the Solid Waste Management Act and the Recycling Act. And so this is supported by the current plain language of the regulations of the Solid Waste Management Act, where materials that can no longer be used for their original intended purpose are solid waste, and that includes automobiles, that includes metals, and appliances.
Are you essentially asking me to reclassify EMR?
Not at this point.
Then, when you say not at this point, but in order for me to accept your argument, I'd have to reclassify them.
Well,
Because they've been classified as a recycling facility by the DEP, correct?
not exactly. So DEP in its briefs stated that EMR is a solid waste facility that receives solid waste, but that it is exempt for reasons that we disagree with.
Okay, so you're essentially asking me to reclassify them. That's the answer, correct?
Yes.
Okay.
Your Honor, I would just say,
One person at a time
Okay.
gets to argue. I'm sorry, I can't do that. It gets to be
I understand, thank you,
chaos, and chaos is not something that I want.
understood.
So in order for me to accept your argument, you want me to reclassify them. But that's, DEP is the one who does the classifications, correct?
Yes, but their current classification is in dispute with the regulations as they currently exist. So you don't have to follow DEP's classification if if it's based on an interpretation of law that is unreasonable. And it's unreasonable because the materials that EMR processes and collects and stores are categorized as solid waste and cannot be categorized as recyclable materials in this
Isn't it
instance.
discretionary what they do?
Sometimes.
Well, their classification of a facility, would that be discretionary by the DEP? When you say sometimes, they make that determination, correct?
But it's in conflict with the law as it exists, so it shouldn't, like, when that classification, when that decision is unreasonable, the court doesn't need to defer to DEP's interpretation.
So you want me essentially to ultimately have a hearing to reclassify EMR on a decision that was made by the DEP within their discretion.
But there wasn't ever really a formal decision made because EMR doesn't require, or based on defendant's argument, they're not requiring EMR to have a solid waste facility permit or even to be approved under the Recycling Act as an approved facility. And so this argument that EMR is a solid waste facility is further supported just by the facts that are undisputed by defendants, which is mainly that end-of-life vehicles, which they do process, and they admit to this in their papers, contain more than just metals. They have plastics, glass, rubber. I drive a car, I drove here, I know that my entire car doesn't contain just metal. And there's a specific prohibition in the scope of the Solid Waste Management Act that says it is first an exemption that source-separated recyclables are exempt from the requirements of the Solid Waste Management Act, but only if they do not contain any solid waste. And so end-of-life vehicles contain a lot of solid waste. As I just mentioned, they have oil, gasoline, mercury switches, a lot of non-metal, non-recyclable materials. And so end-of-life vehicles, as well as appliances or white goods, so think washing machines, refrigerators, things of that sort, because they contain such a significant amount of solid waste, those should be treated as solid waste and are treated as solid waste under the current regulations. If you had, Your Honor, just like a pile of the different components of a vehicle, if you had just gasoline and in a container and a metal door and a glass window and a plastic bumper, and you tried to all throw those things away, they wouldn't say that that is a load of recyclable metals. That would be treated as a load of solid waste under the regulations. And so the other issue here is that because they contain that significant amount of solid waste materials, when they receive them, they're receiving type 13 bulky waste, which includes discarded vehicles and appliances specifically. And since those solid wastes aren't removed prior to shredding the vehicle or other materials, then they should be classified as solid waste. And we also have, Your Honor, two arguments in the alternative should you decide that EMR is classified as a scrap metal processing facility and a scrap metal shredding facility. First is that they have stored solid waste on site in excess of 6 months, which, regardless of the type of material, renders it solid waste under the Recycling Act regulations, because it has been deposited there and is being stored. And we have, Your Honor, photographic evidence of that stockpile at the site that has been admitted. And then our other argument in the alternative, again, for the sake of argument, if EMR is classified as those two types of facilities, then it is also not in compliance with the requirements at NJC 7:26-6.3A5, which requires scrap metal shredding facilities to get a DEP-approved quality control plan, a DEP-approved sampling and analytical plan, and to submit annual tonnage reports. EMR has submitted the first two, the quality control plan and the sampling and analytical plan, but those have not yet been approved by DEP, and that was in 2023. They say that EMR is operating in compliance with those plans. We have not gotten confirmation of that by DEP, since they've only inspected EMR's facility 5 times in the past 10 years. And they have not submitted and admit to not submitting any annual tonnage reports under that provision as well. So that leads to a lack of transparency about what materials they're bringing in, what materials they're producing at the end of their processing. And so those are our 2 arguments in the alternative, should Your Honor determine that the facility is classified as defendants would have it classified.
Okay, so you want me to tell, in your alternative argument, DEP how to regulate EMR's facility?
We want DEP to regulate the facility as the regulations say they should.
Okay, but their regulation, how they choose to go about regulating it is discretionary, correct?
Again, Your Honor, you can defer to DEP's judgment when it is reasonable, and not when it's unreasonable.
How do I determine whether or not it's reasonable or unreasonable based on your argument that it should be reclassified?
You should determine that their classification is unreasonable because it is in conflict with the current regulations that say that end-of-life vehicles and appliances are solid waste.
So I was thinking about this when I was reading all of your papers, and I was trying to envision what that hearing would be. You bringing in experts, to tell me that the DEP, they have their own experts essentially. They're the people that work there, presumably. I was trying to envision what this hearing is that you would be seeking from me, would look like.
This one?
No, not this one. I'm not gonna reclassify someone at an application for restraints. That would be an extraordinary measure for a court to take based upon your interpretation of the regulations.
Well, Your Honor, this facility hasn't been classified under the law. There's no, as I said before, there's no permit that EMR has applied for under the Solid Waste Management Act or the Recycling Act. So there's no decision that we can appeal from DEP. There hasn't been, again, something formal that says EMR is a scrap metal shredding facility and a scrap metal processing facility, so there's no way that we could appeal that decision to the appellate courts and seek redress that way.
So, all right, then my question to the DEP's counsel is, how are they classified?
Well, EMR is classified as a scrap metal facility, scrap metal processing facility, scrap metal shredding facility. And there is no the department doesn't give a formal designation that is a decision to every type of facility in the state. It requires those facilities that have operations that require permits to get permits. And here with EMR, as a scrap metal facility, which its operations are in line with, there is no need for a solid waste facility permit. And
Is
so
there a recycling permit?
there are recycling center permits. There are permits for, or registrations for certain classes of recycling centers. And scrap metal facilities are not a recycling center in that are required to get those registrations.
When I call it a recycling center, I'm wrong. I should be calling it a scrap metal facility.
Scrap metal facility.
And if it's a scrap metal facility, does it get permits?
It does not get there's no permit for a scrap metal facility or registration.
So if someone disagrees with the permitting that's issued, how do they go ahead and challenge the DEP's classification or permit?
Well, so the DEP has the deference to interpret its regulations and goes forward as such. When a facility applies for a permit and gets approved or denied, then there's an avenue for that to be appealed. But here, if there's an issue, if somebody has an issue with the way the regulations are written, the proper course would be to bring that up with the legislature who drafts the regulations or approves them.
Thank you.
Your Honor, can I respond to a couple of those points?
Sure can.
Okay, so first, we also learned through DEP's filings that they also classify EMR as a Class A recycling center, but you just heard counsel say that they are not a recycling center. So the reason that they can't be a recycling center is because in the Recycling Act regulations, in the definition of recycling center, it specifically excludes scrap processing facilities, which both defendants say that EMR is. And so I would also like to point out that we don't need to seek a legislative or regulatory change in this case because the regulations that I've already reviewed and have read out to you provide a basis to regulate EMR as a solid waste facility, but DEP is not doing that at this point. I wanted to move toward the facts that are supporting our plea for preliminary injunctive relief today. Just a quick review that the 4 standards are plaintiff needs to show that the relief would prevent irreparable harm, that it's based on a well-settled legal right, that there's a reasonable probability of success on the merits for plaintiff, and that the balancing of hardships favors the plaintiffs in this case. The irreparable harm in this case is quite clear. As long as EMR is storing materials at its facilities that they are not like inspecting or sampling in any way, that there is a continued risk of fires and the associated public health impacts that come with those fires. Again, Your Honor, the public health impacts, especially toward those who experience asthma and chronic illness. Smoke from a facility that shreds vehicles is unlikely to be particularly safe for anybody, especially young children, elders, and those with chronic illness. And again, that risk remains as long as there is storage of this type of material at the site, which is why these fires keep recurring. And then we already talked about how this is a well-settled legal right. The end-of-life vehicles and appliances that EMR receives and processes are type 13 solid waste under the current regulations. They meet the definition of other waste materials at New Jersey Administrative Code section 726-1.6b, which also specifically points out that any material that is not being used for its original intended purpose is solid waste, even if it's being recycled. And as you heard, they're not requiring EMR to get any permits, but there's also no specific exemption for scrap metal shredding facilities or scrap processing facilities under the law. They're not recycling centers, and they cannot be recycling centers under the definitions that currently exist. There's specific exemptions for recycling centers.
Isn't that kind of the problem, just what you said? There are no definitions under the law that currently exist, which would go to what the attorney for the DEP said. Legislation is what would solve, which is what would fix this gap, is what you're arguing. There's a gap.
Well, we're arguing that there's a gap in DEP's enforcement, but not a gap in the regulations. Because there is permitting required for solid waste facilities, and again, DEP in their brief said that EMR is a solid waste facility.
Oh. He wants you to look at something. I was trying to get your attention.
Yeah, And under the statutory intent of the Solid Waste Management Act, DEP has a duty to regulate and make all solid waste facilities register under the Solid Waste Management Act. However,
If they fall under the Solid Waste Management Act, but wouldn't that be, that goes back to that whole thing, the whole argument of, do I have I keep coming back to this, what authority do I have to tell the DEP how to do their job?
the court, as the court, you can tell DEP what to do when their decisions are not rational
Well,
and
what
against
they-
the statutory intent of the Solid Waste Management Act to regulate the flow of solid waste in the state and to protect public health.
Well, yes, they fell under the Solid Waste Management Act, but every case that you read, the iHeart case and the, what was the name of the other, I have all the cases. They tell me that it falls within the DEP's discretion. Especially the iHeart case and the, Mars case, I gotta find where I put all my cases. It just seems to me that the relief that you requested, and don't think you're the only one I have questions for, is we'll go straight down this table. You're asking me to act as the DEP.
We're asking the law just to be enforced as it's written.
What you're asking, if it were that simple, and that's somewhat of a response that's non-responsive, you're asking me, when you look at the application for preliminary relief and the relief that you're seeking, you're asking me to take on the role of becoming the DEP. And I'm not sure that under the case law, I have the authority to do that. There is a reason why we are separated. And you keep saying to me the same answer over and over again, which has gotten us nowhere. In my understanding of your position, where you say, well, you know, if the DEP is being unreasonable, or they're not doing what you've classified them, or read the regulations in the manner in which you've decided. I'm not sure, though, that gets me over the hurdle that I keep going back to, is their actions are discretionary.
They are when it's in line with the statutory intent of the Solid Waste Management Act, of the Recycling Act. But here, DEP is acting contrary to that statutory intent. And the Solid Waste Management Act, again, requires, it's a statutory mandate, not discretionary, that DEP has to register all solid waste operations in the state. And it does say later on that DEP is able to exempt classes of facilities under the Solid Waste Management Act.
Right?
But in the regulations, there's a section, New Jersey Administrative Code 726-1.7, and subsection C there says that the DEP may not exempt a class of facilities that poses a threat to public health and the environment. So in this set of circumstances, because EMR poses a threat to public health and the environment, as it is shown through the fires and the air pollution impacts of its regular operations, DEP does not have discretion to exempt it here. And it has not made a formal decision that we could appeal to exempt Eastern Metal Recycling.
So then why didn't you file a writ of mandamus to compel a decision, as opposed to asking me to, essentially take over DEP's function by assessing penalties, requiring, I'm looking for your order that you were asking me to sign. I have your verified complaint. But asking me to essentially order them to do certain DEP to regulate, exert manpower, do reviews. I mean, all things that clearly are not within this court's discretion
Well,
or authority.
um,
I don't know, I wanna hear from the others as to why they're not classified, and if they're not classified, then how does anyone file a challenge? You can be seated. Who wants to go for, I mean, I was looking at the DEP, but if EMR wants to go, it doesn't matter.
So, based off of the operations, at the facility, it fits clearly under the definition of a scrap metal processing facility and a scrap metal shredding facility. And, like council said, under the definitions, EMR could fit as a solid waste facility, but not all solid waste facilities require the permits. There are facilities and classes of solid waste facilities that are exempt, and they are treated separately, and that is what is happening here with EMR. So the regulations as they're written, they implicitly exempt the class of scrap metal facilities from the permitting requirements. And you can see that, one, by seeing that they have their own definitions, and within those definitions, it doesn't even reference solid waste facilities, whereas if you look at other solid waste facilities, like the materials recovery facilities, those are specifically referenced as solid waste facilities. You also see that they're exempt from the definition of recycling center. And this together, this reading shows that there is that gap there that has been where the regulations implicitly exempt this class of facilities from the permitting scheme.
So how
And
does
this
someone
is-
challenge that? Say someone comes along and they say to you, we disagree with that they fall under that exemption. How does someone challenge that?
I think that the proper recourse for that would be to, well, there would need to be some sort of decision, right? Because that classification is something that is within DEP's discretion to make.
Okay, so DEP's made a decision that they fall into one of these exemptions. Do they issue, and I just don't know the process, is there a permitting process that's issued? Is there a classification?
There's
Don't know.
so there is no official decision made. If
So
that
where
answers your question.
this group wants me to tell you what to do, or to do something. And when you say to me, someone's standing okay. You have to you're saying, these people come here, CFAT, and do you mind if I call you the CFAT? Because they come here and they say, DEP got it wrong. Reclassify them. And you're saying to me, well, there's no process.
Well, I would be saying that that's something that it's, DEP has the discretion to determine, how the regulations are interpreted. And so what they're asking is for a reinterpretation of the regulations.
Okay, so they interpret it, and I agree, DEP gets to interpret the regulations, but what they're saying to me is, Judge, there is no mechanism, I believe this is what you're saying to me, in part, there is no mechanism for us to challenge that.
I think that is true in the sense of this is not the correct mechanism to do so. Perhaps, a party could petition DEP to make some sort of finding, but this is certainly not the proper avenue.
Okay, but okay. All right, I wanna hear from you more.
Sure.
You can conference with each other for a moment if you want.
Your Honor, I was going to address the crow factor, but Mr. Dillon was gonna address these issues, which seem to be front and forward, so I'm gonna allow Mr. Dillon to
Thank you.
approach the board.
Thank you, Your Honor.
Thank you.
So on the, I'd just like to address your question about the petition process and whether there's any avenue to challenge. I would say, first, it is not at all uncommon for regulatory regimes to be self-affecting. So the rules on their face are quite clear. that EMR is a scrap metal shredding facility and a scrap processing facility. There's really no disputing that under the current definitions and the relevant regulatory history, which I'll get into in a moment. So that's not unusual. And then two, I would say there are well-founded processes under New Jersey environmental law that allow for anyone to petition New Jersey DEP for rulemaking under all of the environmental statutes plus the Administrative Procedures Act. So what the plaintiffs are asking essentially is for you to step into the role of DEP, overturn their reasonable interpretation, and we're getting, I think, hung up on the means for challenging a classification when the rules speak for themselves. It's not a matter of, our position is it's not even a matter of discretion. We fit the definition of scrap metal processing facility and scrap metal shredding facility, and there's really not a reason or really any basis for a party to dispute. But I do want to also—
They disputed that.
Sure, and they're fine to do that. They should petition DEP to draft new rules.
So that's the answer to the question.
I believe that's correct.
Okay, that's what I was.
Yes, that is my
That's
answer to your question.
They should petition, like, there is a process in place, and under the administrative, that's my very first question was, when we started, is why are you here and not with an administrative law judge, which I presume, or the appellate division under court rule, I think it's 223A2. It seemed if there was some type of challenge, you would go right to the appellate division if there was a decision made that was being challenged. So what you're saying to me is what should happen, in your opinion, is that they should file a petition with the DEP to reclassify or to challenge the interpretation that they've taken of EMR.
I don't think that it's on a facility-specific basis like that.
Okay.
Make no mistake, plaintiffs are looking to make law here. This is an exemption that doesn't only affect EMR. This is a statewide issue of monumental importance. The scrap metal recycling industry is a staple of New Jersey's recycling regime, and they don't like the fact that scrap metal recyclers process used autos and appliances, which by definition, the terms scrap metal processing facility, the only items identified in the definition of that term are scrap automobiles and appliances. Those are the items that they claim constitute solid waste and therefore render EMR a solid waste facility. So
How could you ever scrap any of that? You're always going to have some type of solid waste with them.
Of course, and DEP recognized that when they adopted the definition of solid waste facility. So this definition has been on the books since 1993. There may have been earlier definitions, though certainly in 1993, the relevant regulatory history of that term, which I will add, plaintiffs cite and are well aware of, yet they continue to persist in making this argument. DEP discussed the recycling regime in New Jersey and discussed how scrap metal shredding facilities are critical to allowing the state to achieve its recycling goals, and acknowledged that scrap automobiles and appliances will contain up to 20% of non-recyclable content. And they still adopted this definition that exempts them from solid waste permitting. And so inherent in this regulatory decision is this notion that automobiles and appliances of course contain non-recyclable articles, but that's not unique to the scrap metal recycling industry. That is true of all recyclable materials. When you throw away a glass bottle, it might have a plastic label on it. That label is not recyclable. The recycling facility will have to deal with that trash. That doesn't mean that it is no longer a recyclable material. So we're talking about things on a grander scale, but the process is really no different.
So what's being argued to me is there are certain administrative code definitions that CFAT wants me to say EMR falls within. And what you're saying to me is, Judge, no, we've been excluded in the legislation when it was enacted. Regulation, excuse me. Love it. When they enacted this legislation, they specifically envisioned the elves, the cars, the refrigerators, okay.
Yes, that's correct, and I would just like to like explain to you briefly, because it's really hard, if you're not immersed in this industry, it's hard to visualize some of these things.
I think everyone here is very immersed
Yeah,
in
well,
this.
maybe not, because what a MRF is, a materials recovery facility. A materials recovery facility is a facility, it's a complex industrial facility that uses mechanical means to separate trash. They take mixed loads of trash, household waste, or maybe construction site trash, and they send it on conveyor belts, and they use sophisticated sorting processes to remove from that conglomerated waste stream, stuff that nobody decided whether I'm gonna recycle this or put it in the garbage. They take from that conglomerated waste streams things that can be recycled, and they send the rest of the trash to the landfill. That is a MRF.
That's MRF.
And that is, they
But
process.
EMR is not a MRF.
Absolutely not. EMR only handles metal. And you have to understand, EMR is in a commodities-based business. So EMR only takes in metal because they sell metal to their end customers. Anything in addition to the metals that they take in, it's not good for business, because it then adds a disposal cost. And that's a cost of doing business. But that is not, something that we would ever want, to take in extra waste material. And we have painstaking procedures in place to ensure that only metal is collected.
But what about this argument that's being made that you pile up this waste and that's causing a hazard at the site?
Well, I think it's important to distinguish what piles we're talking about. So, when the shredding process occurs, the appliances, old vehicles, just bigger pieces of metal, they all go through a metal shredder. That so it basically makes these big pieces of metal smaller. Anything that's ferrous, meaning it has iron content, gets taken by a magnet, separated out, and then you're left with non-ferrous metal, and then some of this, the seats from a car, or whatever else might be mixed in there. And there is a process to recover the non-ferrous metal, the metal that doesn't have iron in it. And so that material goes through a separate process.
Okay.
And by the way, all of this is regulated very extensively and heavily by DEP through a very lengthy and extensive air permit and stormwater permits. This facility is permitted to the nines. So I don't want to make any mistake about that. And all of these processes are covered through EMR's air permit. And so once it goes through that process,
Okay.
the non-metal, or the non-ferrous metal is extracted from it, also sent off for recycling. And then what remains, which is called ASR or fluff, you might hear that terminology.
I did.
That material is shipped off-site, and the air permit that EMR possesses requires them to remove it off-site in short order. So the materials that are being stockpiled or alleged to be stockpiled, it's just not true.
But they show me pictures of piles.
There was a time when this non-ferrous recovery process was broken, that it was actually broken down.
What do
And
you
so,
mean, broken down?
broken down, like literally broken. It didn't work correctly because of mechanical parts.
Oh, not that there was a break or gap in the
No,
regulation.
no, it was literally mechanically broken. And so
Okay.
for a short time, there may have been some material that piled up, that has since been removed. And can I just spend one moment addressing the source separation argument, right? So,
No, go ahead.
I think I'm covered.
No, it's actually interesting to me.
I'd like to actually, but I think I've covered the source separation argument well. I'd like to address this notion that appliances and vehicles are type 13 bulky waste. So, and I don't want to confuse the issue, but it's been brought up a number of times, and it's really important to cover. So, in DEP's waste disposal regulations, subchapter 2 of the waste regulations, that applies to facilities, primarily landfills, that dispose of waste. Take waste and all the trash that you and I deposit, take it and deal with it. So that's subchapter 2. And any facility that accepts waste for disposal, of course, has to keep track of the waste that they accept, including the waste type. So if you were to send an automobile to a landfill instead of a scrap metal recycling facility, that landfill would be required to record it as type 13 waste. But just because that record keeping definition ascribes a waste identification number to that material, it's irrelevant to the recycling scheme. I should also note, the same section where we're identifying waste types, it includes other waste types that we should maybe talk about. Type 10 waste, for example, which includes all household trash or institutional trash. Your waste basket, that's going to be household waste. If that recycling bin got sent to a landfill instead of a recycling facility, that landfill would have to classify everything in that recycling bin as type 10 waste, even if it was only glass bottles and tin cans. And so that no one would seriously argue that those materials are not recyclable because they have a corresponding waste ID, but that is exactly what plaintiffs are arguing.
Okay. So, from all of that, and what you just told me at the end was critical, because what CFAT keeps telling me is they're reading the administrative code, something falls into the definition of bulky waste. You're saying that is the definition when you talk about a regular trash or regular solid waste management facility, because of course, if they got a vehicle or a refrigerator or something, a washing machine, that would be deemed type 13 bulky waste. However, because it goes to a scrap metal shredding facility, even though that is the literal definition, that doesn't take it out of the being at the as a scrap metal shredding.
Yeah, it's not the definition at all. It's merely a waste ID number that a landfill
Waste ID number.
would have to code that waste as, right? And of course it makes sense, because the definition of recyclable materials itself is materials which would otherwise be waste that are sent for recycling. So of course, anything that doesn't get sent for recycling would be a waste material.
And then you have to classify.
Yes.
And the answer to the question that I've asked over and over again is you petition DEP if you disagree with how something is classified or permitted.
So I would say on the permitting side, there are many permits at this facility that are subject to third-party review and dispute. On this
But where does
question,
that take place?
that would take place not in this court. That would initially take place. You would file a petition with an administrative law judge, I believe, at the DEP, and then you could eventually maybe make your way into state court.
The appellate division, not my level.
Yeah, but that I'm talking on the permitting, right? On a different permitting track. But in this
Isn't
case,
this all the same thing? Isn't permitting essentially running parallel to the classification?
no,
Okay.
it's not.
Totally different.
Yes.
Okay. Sorry.
No, of course.
Anything else?
I think that covers for now. I did just want to clear up some of those key misconceptions.
See, that, you kind of answered part of my question. Remember when I said to you, counsel, what kind of hearing would I have? And it would be people interpreting the regulations for the DEP. Everyone's shaking their head no, but that's exactly what you're asking me to do. Who's taking it? Which one of you?
I could just answer this procedural question, Your Honor, thank you. Is it, Your Honor, there is absolutely no administrative procedure available, administrative remedy available to plaintiff here. There's not one administrative procedure that any of the counsel in this room can point to available to the plaintiff besides availing itself of its rights under the Environmental Rights Act to come here before Your Honor to enforce the Solid Waste Management Act. That is why we are here. That is the only procedure available to the plaintiff today. There's a procedure under the regulations for exempting solid waste facilities from permitting, but the DEP has not taken it. Does that answer your question?
It does, because I look only at the ERA Act, I think the only person that you would have a right to bring a claim against would be that of EMR, not the DEP.
That's not, I'll allow counsel, my co-counsel to discuss the ERA in more detail. I just wanted to make it clear to Your Honor that there is not an administrative remedy available to plaintiff. There is no administrative law judge. There is no hearing request on any permitting decision. The DEP has not made a final decision with regard to this opinion it has rendered here today for the first time. There's no appellate division judge which would hear this without a final agency decision. So, Your Honor, we're availing ourselves of our rights under the Environmental Rights Act. And and if you'd like to discuss the Environmental Rights Act more, I'll allow my co-counsel to
Yeah,
continue.
no, I want you to stay on where you're at, Fran, because I understand, I have taken a tremendous amount of time. I understand,
Mhm.
with the Environmental Rights Act, and I think I am correct on who, we'll get into who is a person and whatnot under the Environmental Rights Act. But, you see, this is what I'm not sure I'm understanding from you, is you're saying, Your Honor, I'm coming here, we're availing ourselves to you because we have no one else to go to.
Mhm.
But wouldn't then the remedy be, as opposed to telling me to reclassify or to categorize or to find the different, me make a determination? I am no expert, and this is not the world in which would even remotely consider myself an expert. Why wouldn't you be suing for them to make a final decision, or simply asking DEP to issue some type of decision?
Your Honor,
You've had since 2020, I don't want this to be unclear. It's not like anyone ran here when you sent your letter under the ERA in 2022.
Your Honor, I'll answer those. There's two questions,
Correct.
so I'll do my best. The first question is, the answer is that the DEP doesn't grant administrative hearings. The first step would be to request an administrative hearing from DEP, which would then, under the Administrative Procedures Act, transfer the matter if it deemed it a contested case, as that term is defined under the Administrative Procedures Act. It would transfer it to the Office of Administrative Law for a hearing. Your Honor, but the DEP denies third-party hearing requests according to the statutory intent of the Administrative Procedures Act, unless there's a statutory or constitutional right to a hearing for a third party. The first party being DEP, the second party being the applicant for a permit, and then the third party being somebody else. So routinely, third parties are denied administrative hearing requests. Here, there is no statutory or constitutional right. There has been no final agency decision. There is no administrative remedy available to the
But that
plaintiff.
denial gives you your remedy.
There is no avenue to even request an administrative hearing. There has been no decision by DEP, and there has been no, normally when DEP renders a final agency decision, it puts at the bottom of the permit, and if somebody feels that they're affected by this permit decision, they want to request a hearing, there are instructions to do so. There has not been any such decision in this case with regard to the Solid Waste Management Act, with regard to its decision to exempt a solid waste facility. And you heard counsel, Your Honor, you heard DEP's counsel just said to you, this is a solid waste facility, but we've decided to exempt it implicitly. Now imagine, Your Honor.
They've exempted it because there are exemptions under the framework that the legislature passed.
No, Your Honor. The
No.
legislature specifically intended and has a provision in the Solid Waste Management Act. If the DEP wants it to exempt a class of facilities, it will do so according to its rules. And then its rules, and again, this is at NJAC 7:26-1.7, there is a rule for exempting classes of facilities, and DEP has not followed its own rules, and that's why we're here today.
Okay, that is not at all what anyone else has argued.
Your Honor, it's in our papers, And council just read that same provision to you.
Right,
My
I'm just
co-counsel
telling
read
you.
that same provision to you before. We have argued that, Your
We
Honor.
are an hour into this, and that's the first time this has been argued.
That's not true, Your Honor.
Yes.
May I
Well-
address a few of those points?
Sure.
So I'll take the last one first. On the classification of facilities, the applicability provisions, the very first provision in the Solid Waste Management Act regulations in 1.1A, on its face, the rules do not apply to recycling. They don't apply when you are recycling recyclable materials, of which all of the materials that EMR handles are. So you don't even need to get into this, what do you call it, classification of facilities and on the administrative remedy piece. All I'm hearing is we don't like the law as written. We don't like the regulations. They don't provide us the avenue we wish we had. And so we use this ERA process to try to generate a controversy, when the appropriate mechanism to make the change that they wish to see, which, make no mistake, this change, if the judge were to find in their favor, you would be changing the landscape for not just EMR, but for scrap metal facilities throughout the state of New Jersey, which I have no doubt is what they want. So they're trying to use this rulemaking step here, which they're asking you to step into the shoes of NJDEP, but NJDEP can only change their regulations and must take time to decide whether it's appropriate to do so. So they have an avenue to seek the change they want. They just don't like it. And I would say that the third point that I just want to address is council keeps saying that there's no administrative remedy for DEP's decision to classify EMR in this way. That is not at all uncommon in DEP's environmental regulations. I think of the air permitting regulations, for example. There are dozens of exemptions to air permitting in New Jersey, and DEP does not issue a finding that a facility doesn't need an air permit unless that facility goes and asks for it. So, and there's no third party who would have any avenue to challenge that non-decision by DEP, if they didn't like it. So that's not at all uncommon. That you can quibble or object to the way in which the rules are drafted and carefully conceived, but the fact that there's not an administrative remedy is really irrelevant to this question.
Well, it's not. If you have people who say we want to challenge something and we have no way of challenging it.
Well, but their challenges to the rules themselves, and they do have a means to do so. They can file a rulemaking petition, and then if DEP denies that petition, they certainly have a right to appeal that.
Thank you. Joe, that's the answer to the question I've asked now, no less than 10 to 20 times. What is the remedy? If there is a remedy, it would, first time I've heard this, is you petition to make a rule change. There is an avenue. And you're saying, no, there isn't. See, this is,
Your Honor, imagine this. Let's play it out. We petition for a rule change. DEP says, no, we don't want to make a rule change. And then there's no rule change. But that doesn't have a specific impact on what is happening here. First of all, we have a request for preliminary injunctive relief. The rule change would do nothing to that. Second of all, we have an allegation that DEP is not following the law or its own regulations. A rule change would do nothing to change that. Your Honor, that is not an administrative remedy available to us today that would solve anything. We need this court, we need the general
why didn't you do it in
equity.
2022?
Because we were in discussions with DEP who promised they were gonna do something about this.
And they didn't,
And they
so
didn't.
3 years, and did you file anything to get a rule change that would give you the right to go right to the appellate division?
Your Honor, going to the appellate division on a rejected rule change would do nothing for this situation. Your Honor, we need this court's general equity power under the Environmental Rights Act to enforce the Solid Waste Management Act, to make DEP follow the law, the legislative branch. So that is not asking this court to step into DEP's shoes. That's asking this court to fulfill its role.
I do believe I do fulfill my role.
Thank you, Your Honor.
Your Honor, may I address the point that DEP did nothing in response to their petition? In fact, the DEP very much did something, and we address it in our papers, but DEP, after receiving plaintiff's initial letter, and there was a series of letters that I think there were 2 from them, 2 from us, DEP issued an enforcement action under Section 6 of the Solid Waste Management Act. And quite frankly, EMR did not agree with the contents of that enforcement action, but nevertheless, after much discussion with the department, agreed to concede the point and did what DEP asked us. That, under the Environmental Rights Amendment, DEP acted. And just because plaintiff doesn't like the response that they received, that does not create a claim under the Environmental Rights Amendment.
No, well, what I'm wondering, and I was hoping maybe the DEP would be addressing this, is under the Environmental Rights Act, what if any authority do you even fall under it? You're not the only case in which I saw the DEP could be a party was one where they were the actual polluter, and someone was seeking to get them to correct their polluting.
That's correct, Your Honor. The ERA does not provide for a cause of action against the department in its capacity as the enforcer. It is true that an agency is a person under the ERA, but like we said, that would be for when the agency itself is doing the polluting. Here, there are no cases, and in fact, there are no cases to suggest that DEP could be a defendant for any alleged failure to enforce. And the plaintiff does not point to any legal authority saying that that is the case. So, no, Your Honor, DEP cannot be a defendant in an ERA action for a alleged failure to enforce, and that is one of the main reasons that we're asking this court to dismiss the complaint as to DEP, and that is a jurisdictional issue.
All right, anything else?
Yes, Your Honor. First, I did want to respond to the scope of the Solid Waste Management Act regulations that EMR's counsel pointed to, and that's at the Administrative Code 726 1.1A1. Throughout their papers, both defendants cite to mainly the first part of that provision, which exempts the purchase, sale, collection, storage, transport, or controlled processing of source-separated or commingled source-separated recyclable materials. However, the second part of that provides that the materials must be free from solid waste. You heard from EMR's counsel that end-of-life vehicles contain 20% solid waste, and that's not in the regulations anywhere, that any material that contains, or load of materials that contains 20% solid waste is also exempt. We have case law that says maybe 10% is considered de minimis and exempt, 10% of solid waste in the load of recyclables, and then it's exempt from the Solid Waste Management Act regulations. But Your Honor, there's nothing in the plain letter of the law that exempts materials that have 20% or less solid waste from the Solid Waste Management Act. And then, Your Honor, I wanted to talk about DEP's enforcement under NJIC 726-6.3 that EMR's counsel was just referencing. They specifically disagreed that that provision even applied to them in the first place, and the plain letter of the law would support that. So let me put up quickly. That is again the provision that requires scrap metal shredding facilities to have a quality control plan, a sampling and analytical plan, and annual tonnage reports, which again, Your Honor, they're not in compliance with any of those things because there's sampling and analytical plan and quality control plan have not been approved by DEP, even though they were submitted in 2023. And since then, they still have not submitted any annual tonnage reports, which they admit to in their papers. They call this a mere paperwork violation, but it's still a violation of the law. They are not following it. And it also, DEP in its brief says that compliance with that provision is what exempts EMR from the Solid Waste Management Act, but that is not true because this subchapter only applies to the solid waste planning regulations. It doesn't apply to the permitting requirements. It doesn't apply to the registration requirements, the operational requirements, or anything like that. And it only applies to what EMR produces. It applies to that automotive shredder residue. And again, it's this 726 6.3a says that this subchapter applies to all solid waste as defined in that list, that type 13 waste is captured by this and is not exempt, but dry industrial waste type 27, which is the automotive shredder residue, is exempt, but only if they submit that paperwork, including the sampling and analytical plan, quality control plan, and annual tonnage reports, which they have not done. And so this subchapter does not provide DEP with the power to exempt EMR from all of the Solid Waste Management Act regulations, because it's not exempting what they receive.
Okay.
And then I wanted to speak quickly about the Environmental Rights Act. It is really clear that DEP is a person within the definition of the Environmental Rights Act.
It is.
Yeah. It includes any agency or instrumentality of the state, and that's at New Jersey Statutes Annotated 2A:35A-3A. I didn't, in my studies, uncover any case law that prohibited including DEP as a defendant. So on the flip coin of what DEP's counsel was arguing, there's also nothing in the statute or the case law that says DEP cannot be a defendant in those actions. And I think that is all I
Thank
have to
you.
respond to you.
Anyone else? Council?
Do you want any argument on the four crow factors?
If you want to, you can. I have not cut anyone off, and I have my entire afternoon. If you want to, for the record, you certainly can make any argument you want.
Your Honor, I think we addressed these well in our papers. Again, I wanted to give you the opportunity if you had any specific questions, but I think they are laid out well in our papers. The bottom line is there hasn't been a showing, or certainly not a showing by the clear and convincing evidence that's required to meet the four crow factors to grant the extraordinary relief that the plaintiff seeks here today. And again, the underlying issue of the interpretation that we disagree with and agree that DEP has already established, and the papers support that the interpretation of what EMR's facilities fall into scrap metal shredding facility or scrap processing facility is clear, and it's well settled law. There has not been a showing of irreparable harm here for a number of the reasons that Your Honor has already pointed out, the delay in pursuing the action. I wanted to address, again, the fires that were brought up. That's truly a red herring. The settled legal right is whether or not there was a right presented to reclassify EMR and identify them as a MRF. That showing is not well settled and that has not been established. The other factors that is required by clear and convincing evidence is that there's the likely probability of success on the merits. I think the arguments show today there's not. And finally, on the balancing of the equities, the only arguments presented on those issues is that of speculative nature, of potential harm. We've already talked about that in our briefing, how the fires have been addressed and how EMR has worked with the city of Camden under a MOA to address and make sure they have enhanced and additional fire protection measures. Whereas if you balance the hardships to EMR, which would be changing the status quo, they certainly would be a significant financial burden, potentially implicating employees as well as customers. So with that, we just present that the plaintiff has not made an adequate showing, especially on clear and convincing evidence, and have not met their burden for preliminary injunctive relief.
Your Honor, can I make one final remark?
Go ahead.
Request for clarification. Your Honor, I would just like any decision today to be undergirded or underpinned by the fact that, the undisputed fact, DEP alleges in Michael Hastree's certification and in its papers, that DEP has visited the site 5 times in the last 10 years, despite 7 fires and known issues with solid waste violations, air pollution violations, OSHA violations, and numerous fires that have caused big troubles and health problems for local residents. DEP has visited the site 5 times in the last 10 years. Thank you, Your Honor.
Okay, anything else? I'm gonna take a break. Council, my chambers will reach out to you when I have a decision. I'm not gonna get one to you today. I'm going to think about that. I appreciate the zealousness in the arguments and the briefing in this case. My staff will reach out when I have a decision. You'll be able to either listen by Zoom or order the transcript. Thank you.